Justice Scalia, not just judges, that it was a subject that could engage everybody. There's a hunger to figure out what the Constitution means, quite apart from the explicit things that it says. And that hunger, I think, is particularly strong today, just 34 days before a presidential election that is likely to make a profound impact on what the Constitution, as a living framework and not simply an artifact preserved in pristine conditions under glass, means to our lives and to the life of our republic. As far as the physical constitution of our republic is concerned, I should report that I last saw it in the building where it has long been housed, the National Archives of the United States, 22 years ago last month, on its 199th birthday, on the same day, as it happens, that William Rehnquist, a moderate by comparison with some jurists who have since taken the bench, although he was thought to be quite a conservative at the time, was sworn in as the late Chief Justice of the United States. A few years later, right around the time that a very promising Harvard law student named Barack Obama, I think you've perhaps heard of him, was my research assistant, I learned that the fading parchment lying in state at the archives was not, in fact, the Constitution that the states ratified in a process that began in 1787. Turns out that there were two versions of the Constitution, one handwritten and one printed, and it was the handwritten version that ended up in the archives, although it was the printed version that the states actually ratified. Now, the story of how that came to pass and of the intriguing differences, mostly differences of punctuation, but sometimes punctuation can matter, that exist between the two versions, that's a tale for another time. What matters to me this evening is that while the two versions differ in a few potentially significant particulars, the version that gives us chills when we view it under glass at the archives is, to quote Yale's Akhil Amar, probably good enough for government work. And what matters even more is that neither version, neither the printed one nor the handwritten one, could become the supreme law of our nation just because it says so. I mean, it says, this Constitution is the supreme law of the land. Big deal. We could here, if we had nothing else to do this evening, write a different Constitution. Who knows what it would provide? Right to fair housing, limits on mortgage foreclosure, you name it. And we could say, this is the supreme law of the United States, and we feel we accomplished even more than the Senate is likely to accomplish, however it votes on the bailout bill tonight. But that wouldn't make it the supreme law of the United States. What did make that the supreme law of the United States? It was ratified by 9 of the 13 states, and at that point, by its own say-so, it became the law among those 9. The other 4 just had to join, or else they would have been frozen out. That wasn't the rule that the Articles of Confederation laid down. It said you need unanimous ratification. Besides, the folks who ratified it were a bunch of slave owners, property white men, all of them. No Indians, no African Americans, no women, no poor people. In a democracy, does that make something the law of the land when you just look at the narrow constituency that ratified it? The fact is that the Constitution evolved over time. It was amended in various ways. The amendments were ratified in a process, each instance of which represented a kind of readoption of the Constitution as a whole. The Constitution that we now accept as our own is ours because and to the degree that we have embraced it as ours over the long, sometimes bloody history of our republic. It's what we have made our own over the course of the challenging project that the Constitution's preamble set out, the project to form a more perfect union. The Constitution by which we govern ourselves I would submit, is not the parchment that lies in state the archives, nor the printed version lost to history. It is the living law, as ratified, amended, interpreted over time, and thereby absorbed into an ongoing organic tradition that frames our political order. In fact, it's only because the Constitution is subject to a process of continuing revision, both in its literal text through formal amendments and in our understanding of the larger framework of which that text is merely a skeleton and a shadow. It's only because it is subject to a process of continuing revision that we may accept it as our supreme law without, in effect, ceding to long-dead heroes an unalterable and unconscionable control over our political and legal destiny. You know, when people say that it is we, the people, who govern the United States of America, and when they express misgivings about being governed by the Constitution as interpreted by 9 characters in Washington, they're kind of missing the boat. Even if we didn't have 9 unelected, independent judges who, for various good reasons, are given the authority to interpret the Constitution from time to time, we would still have something of a puzzle. How come we are governed by a document written by dead people? Do we believe that it is democracy to be governed by the dead hand of the past? The answer for most people is that it is a continuing process. It's not the dead hand of the past, it's the living, ongoing hand of the present that continually revises our understanding of what the Constitution of the United States is and what it means. And what I address in the book is not particularly the much contested question of just how activist or pacifist, how strict constructionist or otherwise the 9 justices of the Supreme Court should be. That's an interesting and important question that we will debate until the end of the Republic. What I'm interested in is the Constitution itself, which has to be interpreted not only by 9 justices, but by the President, by the Congress, ultimately by the people of the United States. There are a lot of constitutional questions that don't come before the Supreme Court. Did William Jefferson Clinton, commit impeachable offenses when he lied under oath about his affair with Monica Lewinsky? Came before the Senate, never before the court. And some senators believed that those offenses, even if proven, were not really high crimes and misdemeanors. Did George H.W. Bush or George W. Bush commit impeachable offenses by waging war on what some people believe are false pretenses? You can be sure that the Supreme Court of the United States will never answer that question. But as citizens, most of us need to come to a view about matters of that kind. And when we do, we are interpreting a living document. And we're interpreting a document which does not answer on its face all the questions we might ask of it. Over a century ago, James Russell Lowell warned that too many people had come to see the Constitution as a kind of machine that would go of itself. 2 decades later, Woodrow Wilson recognized that the Constitution is better conceived not as a machine, but as a living thing. What he didn't add was that it's a living thing with no body or mind, no moving parts or organs or spirit, separate from the bodies and minds and spirits of the people themselves, people whose constant vigilance is the lifeblood of constitutional survival. About 20 years ago, the Wall Street Journal recounted the results of a mock constitutional convention that was held in colonial Williamsburg by some 52 Virginia high school students.